appeal in the matter of Chowdhury and the Secretary of State for the Home Department.
Yes.
Lady, my lords, I appear for the appellant this morning with Mr. Raza. Mr. Biggs appears for the Secretary of State. Lady, my lords, the Secretary of State made an application yesterday
Yes.
to rely on the documentary evidence that was before the First Tier Tribunal. In that application, there is a confirmation that the Secretary of State considers that it is necessary for the court to read that evidence. On the basis of that confirmation, given for the first time yesterday, the Secretary of State's application is not opposed. I'm content for the court to admit the Secretary of State's bundle, and I'll leave it to my learned friend to explain why it is necessary for the court to read that evidence.
Very well. Well, our provisional view in any event was that in accordance with usual practice in this court, we would be willing to look at anything that anyone wishes us to see without taking time on procedural applications at this stage.
Yes.
And then we'll refer to anything insofar as we think it's relevant and helpful in the course of our judgments.
Yes. I'm grateful. Lady, my lords, 10 years ago, in 2014, BBC Panorama exposed widespread cheating in relation to the taking of TOEIC English language test. The cheating in the paradigm case would involve use of a proxy to take the speaking part of the test. Now, following that documentary, the Secretary of State accused over 40,000 migrants of deception and issued decisions cancelling and refusing leave to remain in respect of those who were said to have obtained leave by deception by relying on the TOEIC certificates. That resulted in a series of test cases, and ultimately in 2017, this court held that those who are accused of TOEIC fraud are entitled to a fact-finding hearing. This court and various constitutions of the upper tribunal also gave guidance as to the approach to be adopted in such fact-finding hearings. The guidance, in short, requires there to be a fact-specific assessment in each and every case. An applicant accused of fraud would go to a fact-finding hearing and will tender himself for cross-examination. In the paradigm case, the applicant would deny the allegation and say that he sat for the test himself and did not use a proxy. It is the task of the judicial fact finder to hear evidence from the applicant and decide whether to accept it or reject it. There's nothing with respect remarkable about the exercise, and the tribunals conduct these sort of fact-finding hearings on a daily basis. The appellant in this case, like many others, is accused of TOEIC fraud in 2013. He spent around 7 years trying to clear his name, and ultimately he received a fact-finding hearing before the First Tier Tribunal in 2022. He attended that hearing. He gave evidence that he took the test himself and tendered himself for cross-examination. Now, that was the Secretary of State's opportunity to challenge his account, but she did not. The First Tier Tribunal nevertheless considered the appellant's evidence objectively and believed him. The First Tier Tribunal found that he did not cheat and allowed the appeal on that basis.
Mr. Malik, when you say that the Secretary of State had the opportunity to challenge his account but did not, was he cross-examined on behalf of the Home Office?
No.
At all?
At all, yes. Yes. Now, the First Tier Tribunal found that he did not cheat and allowed his appeal. The Upper Tribunal on the Secretary of State's appeal set aside the First Tier Tribunal's decision, and this, of course, is an appeal from that decision. The sole issue before the court, my lady, my lords, is whether, as the Upper Tribunal held, the First Tier Tribunal had erred in law in making its findings of fact. And I shall seek to persuade the court to answer the issue in the negative and restore the First Tier Tribunal's decision. So subject to any observations, what I propose to do this morning is to address you briefly on two topics of law. First, legal principles that apply on appeals from the findings of fact made by the First Tier Tribunal. And second, the legal principles that apply as to fact-finding hearings in TOEIC appeals. So after addressing you on the law, I will address you briefly on the facts. We'll take you to the decisions made below and make submissions as to why the First Tier Tribunal's decision contained no error of law. So addressing you first on the law, and starting with the principles that apply on appeals from the findings of fact. Now, the appeal to the from the First Tier Tribunal to the Upper Tribunal is governed by sections 11 and 12 of the Tribunals, Courts and Enforcement Act 2007. You have those provisions behind tab 1 of the authorities bundle. Now, section 11 is at page 3. And my lady and my lords will see that an appeal, a right of appeal to the Upper Tribunal is limited to a right on a point of law arising from a decision made by the First Tier Tribunal. So there is no right of appeal on facts. A party cannot appeal to the Upper Tribunal on the basis that the First Tier Tribunal made the wrong decision. The appeal is available only on a point of law, and the point of law must arise from the decision made by the First Tier Tribunal, not a general point of law. Section 12 concerns the task of the Upper Tribunal on such appeals. This is page 6 of the bundle. So the question that the Upper Tribunal must ask itself, this is subsection 1, is whether the First Tier Tribunal, in making the decision, made an error on a point of law. If the Upper Tribunal decides that there is an error of law, the Upper Tribunal can then set aside that decision and remit the matter for a rehearing. So there is no bar, there is no jurisdiction to remit the matter for a rehearing absent an error on a point of law in the first decision. So the point in subsection 1 goes to the jurisdiction. There is one authority that I will take you to, the authority that in my respectful submission neatly summarizes all applicable legal principles. It's a recent judgment of this court in a case that isn't very different. It's behind tab 13 of the authorities bundle, the judgment of this court in Ulla. Now, Ulla is a similar case. The appellant, Mr. Ulla, was accused of dishonesty by the Secretary of State. He attended the fact-finding hearing. He gave evidence that he wasn't dishonest and intended himself for cross-examination. His evidence that he wasn't dishonest was not directly challenged in cross-examination. The First Tier Tribunal, being the fact finder, believed his evidence and held that he wasn't dishonest. Just like this case, there was an appeal to the upper tribunal, and the upper tribunal set aside the First Tier Tribunal's decision. Mr. Ullah appealed to this court, and this court restored the First Tier Tribunal's decision, holding that there was no error of law in it. The reasons that the court gave apply to this case with equal cogency. So may I respectfully take my lady and my lords to paragraph 22 of the judgment. This is page 324 of the authorities bundle. That paragraph falls under the heading applicable legal principles. And my lady and my lords will see a three-stage test, a three-stage approach. The Secretary of State has the evidential burden of adducing evidence raising an issue of fraud. The appellant has a burden of raising an innocent explanation. And the third stage requires the Secretary of State to prove on balance of probabilities that the explanation is to be rejected. So there's no burden on the appellant to prove that he is innocent or his explanation is good. It is for the Secretary of State to prove that the explanation must be rejected.
Yes, but the first sentence of paragraph 22 encapsulates that proposition.
Yes.
The legal burden of proof remains throughout on the
Second.
Secretary of State, although the evidential burden
Yes. Yes. So my lady and lords will see that there are references to several authorities at paragraph 22. Now, all these are TOEIC cases. The authorities that are referred, you have references to those authorities in skeletons, and some of those authorities are in the bundle. But these are the principles. Now, if you then look at the end of page 325, you'll see a heading, UT's jurisdiction and error of law. And under that heading, Lord Justice Green summarizes the principles in 6 short points. Now, these are the principles that I respectfully invite my lady and my lords to apply to test whether the First Tier Tribunal has erred on a point of law. Principle 1, the First Tier Tribunal is a specialist fact-finding tribunal. One should not rush to find an error of law simply because the upper tribunal might have reached a different conclusion on facts or expressed themselves differently. You get that from the judgment in Ahed Sudan. Where a relevant point is not expressly mentioned, the upper tribunal should be slow to infer that it hadn't been taken into account. Now, when it comes to the reasons given by the First Tier Tribunal, the point that is made in this case, it is appropriate to exercise judicial restraint. The upper tribunal should not assume that the First Tier Tribunal misdirected itself just because not every step in the reasoning is fully set out. Now, so far as the adequacy of the reasons are concerned, this is the next point. The issues for the decision and the basis on which the tribunal, the fact-finding tribunal, reaches its decision may be set out directly or by inference. Principle 5 is relevant given the point that is taken in the respondent's notice. The judges sitting in the First Tier Tribunal are not required to expressly refer to the relevant authorities. There is now a practice direction by the senior president in place, echoing that point, that judges sitting in the specialist tribunal are to be taken to be aware of the relevant authorities and to apply them. And the final point is that, well, the nature of the fact-finding assessment is that different tribunals on the same facts and evidence may come to different conclusions. And the fact that one tribunal has reached what appears to be an unusually generous view of the facts does not mean that there is an error of law. So these are the principles that, in my respectful submission, apply to this case too. Now, can I then take you to page 329 of the bundle? My lady and my lords will see a heading just above paragraph 36, Griffiths. Now that, of course, as Lady Millard knows, is a case from civil jurisdiction on cross-examination. And if you look at the quotation at paragraph 36, the last sentence of the quotation, if a party has decided not to cross-examine on a particular important point, he will be in a difficulty in submitting that the evidence should be rejected. Now, Lord Justice Green then considered the position in relation to the allegations of dishonesty. And if you look at paragraph 37, you'll see what is quoted there, that that point applies with greater force when a party intends to accuse a witness of dishonesty. Now, the Secretary of State sought to suggest that the principle in Griffiths do not apply to the tribunals, but Milady and Milords will see that that submission was rejected, and you'll see that the appeal was ultimately allowed.
Mr. Malik, can I ask this? As an advocate, I regarded it as my duty to put, to use a particularly blunt phrase, my case to a witness where any aspect of my case disagreed with the evidence that they had given, or, for example, was contained in their witness statement.
Yes.
That hasn't changed, has it?
It hasn't changed. But as an advocate, as counsel, in my respective submission, your duty is to exercise a judgment as to whether it is appropriate to challenge a witness. And it happens from time to time that counsel take the view that it is not appropriate to cross-examine a witness on a particular issue. That is a matter for the judgment of counsel, advocate who is representing a party. But just to be clear, Milady, I'm not inviting the court to allow my appeal simply on the basis that there wasn't cross-examination. That isn't the point. But I need to, of course, make that point essentially for the context, and essentially to flag that for my learned friend when he'll come to address the court on the issue of the respondent notice. So if my learned friend says that, well, the judge hasn't expressly dealt with X, Y, and Z in the decision, my learned friend, in my respective submission, will need to show how and where those points were put by the Secretary of State to the witness, and whether any submissions were made on those factual issues to the judge. But that's how I put my case, and I do not disagree at all with Milady that as an advocate, the duty, of course, is to put your case to the witness. But if you exercise your judgment and if you decide that, well, it's not appropriate to challenge the witness, then that's your decision, and you live with its consequences.
Well, I understand all of that, and I wouldn't take issue with the way in which you put it. But that exercise of judgment goes to the weight, if you like, of the different points that are required to be put. And some are more important than others. An allegation of dishonesty is an important one, is it not?
It is, but Milady, and this is the point that Lord Justice Green was making. If you're alleging that someone is dishonest, and if that person gives evidence in chief that he is not, then you have to look into his eyes and say that no, you were dishonest. You were dishonest because look at my evidence, the evidence that the Secretary of State now adduces before the court. That look at that evidence. Your evidence is incredible because you cheated. Here's the evidence. What's your explanation? But if you don't do that at the fact-finding hearing, at the trial, and if you adduce the evidence before the appellate court, then you have to explain whether that evidence was put to the witness and whether the witness was challenged. That is the task, in my respective submission, of my learned friend. If he relies on the evidence that is before the court, he needs to explain whether that evidence was put to the witness, whether he was given the opportunity to address it.
But you've said already that the appellant was not, in fact, cross-examined at all.
Yes.
Now, if that's right, speaking for myself, I don't follow the submission you made a moment ago that you're not asking this court to allow the appeal simply on the ground that there was no cross-examination, because I don't see how, on your submission, if there was no cross-examination, then the answer is always going to, whatever piece of evidence it is, the answer is going to be no, it wasn't put to the appellant, and his evidence wasn't challenged. So doesn't it simply come down to the proposition that because he was not cross-examined, the appeal has to be allowed?
The reason why I put my case in the way I put it is because the First Tier Tribunal did not say in its decision that, well, there is no challenge to the appellant's evidence, and for that reason I allow the appeal.
Right.
That was a course that would have been open to the First Tier Tribunal. But the First Tier Tribunal, as I said in my opening, I'll take you to the decision, nevertheless considered the evidence objectively and gave reasons as to why that was plausible, credible evidence. And if in the process there is some error of law, then I don't pretend that, well, the court cannot do anything about it. But that is the context in which, in my respectful submission, Milady and my lords will consider the points that are made in the respondent's notice. So this is ULA, the approach that applies from the findings of fact from the decisions made by the First Tier Tribunal. Just moving on to my next point of law, which is the principles that apply in TOEIC appeals. It is obviously just impossible for me to take you to every single leading authority on the subject of TOEIC appeals. But what I propose to do is, given the points that are made in the respondent's notice, is to take you to key authorities in a chronological order and make some very brief submissions as to their effect. But the ultimate point that one gets from all these authorities is that the question as to whether a person has cheated is fact-specific, and the answer will depend on whether the fact finder accepts or rejects the appellant's account. Now, in the Secretary of State's supplementary bundle, the Secretary of State has produced witness statements from Peter Millington and Rebecca Collins, and the position is that it is necessary for the court to read those lengthy witness statements. But those two witnesses gave oral evidence before the upper tribunal in the first authority that I will take you to. Now, both those witnesses were cross-examined over several days, and the upper tribunal made findings of fact as to their evidence, the evidence that you have in the Secretary of State's supplementary bundle. So instead of reading those lengthy witness statements, in my submission, the focus must be on the judicial assessment by the upper tribunal of those witnesses. So the first authority that I'll take you to is behind tab 3 of the authorities bundle. This was the first test case, SM and Kadir. You'll see that this is a decision by the presidential panel. The hearing was said over 5 days. The tribunal heard evidence from the witnesses, the Secretary of State's witnesses, those who were responsible for the Panorama documentary, and an expert, etc. And what is said, the summary of the conclusions is in the judicial head note. This is the head note that is written by the judges, that the Secretary of State's evidence is enough to meet the evidential burden, no dispute about it, but the Secretary of State wasn't able to discharge the legal burden. Now, may I take you to paragraph 63 of the judgment? And I take you to that paragraph because the Secretary of State asks you to read the witness statements of Peter Millington and Rebecca Collins. So paragraph 63, page 55 of the bundle, the upper tribunal analyzes that evidence and says that, well, both witnesses were truthful, but there was a catalogue of shortcomings in their evidence. And you will then see that those shortcomings are listed in 10 points. So this is where, in my respective submission, focus ought to be, if the court is minded to go into facts and look at the facts itself. You'll see that, well, the witnesses had no qualification to give evidence on the subject. ETS was the sole arbitrator, and so on. So that evidence, of course, is enough to raise the evidential burden, but not enough to meet the ultimate legal burden. So that's the first paragraph that I'll take you to. And then if you look at paragraph 69, that summarizes a submission that the Secretary of State made. Mr. Dunlop made that submission on behalf of the Secretary of State and said that when it comes to the legal burden of proof, the fact finder must consider 7 factors. That remains good. And you'll see, and these are relevant on this case. What is it that a person has to gain from being dishonest? What is it that he has to lose? What is known about his character? Of course, good character is not a defense, but it's relevant. What is known about culture or environment in which he operated? How he performed under cross-examination? Whether the tribunal's assessment of the English language skills is consistent with the TOEIC scores, and whether his academic achievements are such that it was unnecessary or illogical for him to have cheated. Now, just for the purpose of the note, because I have, of course, limited time, I'll not take you to every single authority. Now, this particular paragraph was expressly endorsed by this court when the matter came before this court. Now, you have the judgment of this court, again, just for the purpose of note-taking, behind tab 4 of the authorities bundle. And it's paragraph 18 of that judgment, the judgment of Lord Justice Beatson. He referred expressly to paragraph 69, noted that there was no criticism by the Secretary of State of that approach, and that approach remains good. So this simply reflects the need to conduct a fact-finding assessment of all relevant factors. Now, Milady and my lords will see that both appeals were allowed. The appellants gave oral evidence. They were rigorously cross-examined by the Secretary of State, but the tribunal believed them. The tribunal accepted that, well, they sat the test and allowed both appeals on that basis. The next judgment that I'll take you to, the next authority is MA. You have that judgment behind tab 5 of the bundle. So by that time, the Secretary of State had improved on the evidence. The Secretary of State had used further expert evidence, further witnesses, and the tribunal heard evidence, I think, from three witnesses. Looked at everything in the round and then see what is the conclusion. The conclusion is at the judicial head note Roman 1, that despite all the evidence that the Secretary of State has adduced, whether a person has cheated is a question that is intrinsically fact sensitive. So it's not the case that the Secretary of State's evidence on its own is enough to discharge the legal burden. You have to look at the explanation and then decide what to do. Now that appeal failed, and can I just show you one paragraph? It's a lengthy paragraph, but it's important to look at it. This is paragraph 48 of the judgment, page 100. So the upper tribunal did not say that, well, the Secretary of State's evidence is strong enough to discharge the legal burden of proof. you'll see that the appellant MA gave evidence and he was not believed. He was not believed for the reasons given. The first reason was that there were significant gaps in his written evidence. This is Roman 1. Roman 2, he failed to even provide a most basic description as to how he traveled to the test center. Third, his oral evidence wasn't consistent with the documentary evidence. So in short, his evidence, he wasn't a credible witness. And the appeal failed because he wasn't believed. So this is MA, the authority for the proposition that despite all the evidence, well, not only the two witnesses, but also the further expert evidence that you have in the supplementary bundle is not enough on its own to discharge the legal burden. You've got to look at the facts. You have to evaluate the oral evidence. You then, milady and my lords, you'll get to the judgment of this court in Asylum. So if, milady and my lords, you wish to see a summary of all TOEIC litigation, then you'll find that summary in Asylum. This is the judgment of Lord Justice Underhill. It's behind tab 6 of the authorities bundle, page 111. Lead appeals on TOEIC. So this is the authority where this court essentially said that those who are accused of TOEIC fraud are entitled to a fact-finding hearing. Now, if you go to page 120 of the bundle, you'll see a heading, the TOEIC litigation to date. Sorry, I'll not.
Sorry, what page was that?
Page 120. There is perhaps no need for milady and my lords to look at the entire summary, that is paragraphs 22 to 23. But if milady and my lords are interested in the subject generally and wish to see what various courts and tribunals have said, then it's paragraphs 22 to 33. It all comes down, as said, to this, that whether a person has cheated depends on whether his oral evidence is accepted or rejected. Now, the application that the Secretary of State made yesterday makes a reference to the college being a fraud factory and the voice file not matching the voice of the appellant. Again, I'll leave it to my learned friend to develop those points if he wishes to, because no such points were made below. There is no evidence before you, or was in evidence below, that the college where the appellant took the test was a fraud factory. But I do ask you, my lady and my lords, to look at paragraph 33, just in anticipation of the point that my learned friend may make. Paragraph 33, Lord Underhill deals with a case where the test was taken at an established fraud factory. Fraud factory is a college that is bogus, they're producing the results. An established fraud factory, not this case, but where the test is taken at an established fraud factory, and also where the voice file does not record the applicant's voice, or no attempt has been made to obtain it. Now, in all these cases, there is obviously a mismatch between the voice of the appellant and the recording that appears. In every single case, the voice doesn't match. I mean, of course, if there is a match, then there is no case. In every single case, there is a mismatch. But see what Lord Underhill said about those extreme cases. That even in that extreme case, there is still a need to conduct a fact-specific assessment. And a lot would depend on the oral evidence that the appellant gives and the evaluation of the fact finder of the oral evidence. So that, my lady, my lords, is awesome. And you then get to the next test case, DK and RK. The authority that is highlighted by my learned friend in his skeleton in the respondent's notice. There were two DK and RKs. The relevant DK and RK is behind tab 9 of the authorities bundle, page 175. Now, of course, there is an issue. The Secretary of State says that, well, the guidance in DK and RK was not applied. So it's important in my submission to identify that guidance. Now, the guidance is in the judicial head note. Now, these are the head notes drafted by judges. And the whole idea of the system of setting out the guidance in the head note is that it avoids judges sitting across the country from actually analyzing the evidence that is referred to in the decision or making extensive references to it. So you have a summary of the guidance in the head note, and you'll see, and that is the guidance that the judge, as I shall seek to demonstrate, applied. The summary is in 3 points, the guidance is in 3 points. The Secretary of State's evidence is sufficient to discharge the burden of proof, that is the evidential burden, not the legal burden, so to require a response from the appellant. No dispute about it. The burden of proving fraud is on the Secretary of State, so there's no burden on the appellant to prove that they are innocent. The standard of proof is balance of probabilities, and the burden does not switch. The presidential panel analyzed the evidence again, including further expert evidence. The appellants, DK and RK, were submitting to the presidential panel that, well, the Secretary of State's evidence is awful, it's bad enough, it's not strong enough to meet the initial evidential burden, and they don't have a case to answer. That submission wasn't accepted, and there is no dispute as to its correctness. Now, the upper tribunal emphasized in my submission repeatedly throughout this decision, that the Secretary of State's evidence is not conclusive, I'll ask you, Milady, my lords, to look at two paragraphs where the upper tribunal makes the point. The first is paragraph 103. This is at page 203 of the bundle. Last sentence.
I'm sorry, which page?
Page 203,
Thank you very much.
paragraph 103.
Thank you.
So you'll see a heading analysis. So the evidence adduced by the Secretary of State is reliable enough to meet the evidential burden, but see the very last sentence. By reliable, we do not mean conclusive. But there's no good reason to doubt it, but it's not conclusive. The upper tribunal makes the point again in my respectful submission at paragraph 107 that the Secretary of State's evidence is not determinative. And the upper tribunal then applied those principles. The upper tribunal did not dismiss the appeals because the Secretary of State's evidence alone was enough to discharge the legal burden of proof. Can I just show you why the appeals failed? This is page 210 of the bundle. Page 210, paragraphs 132 onwards. DK and RK both gave evidence. They were disbelieved. DK was not frank about how why he took the test in Watford. Of course, if you live in one city and if you give the test in a different city, you've got to provide an explanation as to why you traveled. RK was wholly incredible. The evidence was riddled with inconsistencies. This is paragraph 134, paragraph 135. The tribunal did not believe them. So their oral evidence was rejected. And for that reason, the appeal failed. So this is DK and RK. It's not the authority for the proposition that the Secretary of State's evidence is bulletproof. It proves fraud. Makes the point that, well, a lot would depend on a person's explanation, person's account.
Mr. Manley, can I just ask you this? Both in the judicial head note, which you showed us, and I could see in a number of other passages in the course of the judgment, the upper tribunal in DK and RK makes reference to the fact that the Secretary of State has discharged the burden of proof.
Yes.
Did they make it clear that they're referring to the evidential burden rather than the legal burden?
Well, they did not, regrettably, and that well, they did not, at least in the judicial head note, and that regrettably, I say this with the greatest respect and diffidence, has caused some uncertainty, and you have the order made by Lady Justice Andrews as to why she granted permission.
Yes.
They did not, but if you look at paragraph 1 of the judicial head note, the paragraph that I've shown you,
Yes.
there can be, in my respective submission, little doubt that their reference to the burden of proof is to the evidential burden. The reason, my lord, is that
No, I'm not doubting that.
Yes.
I was just wondering
whether they have said that
speaking
expressly.
for myself, because if I'm honest, if
Yes.
I were an FTT judge, I would have found it helpful
Yes.
if the upper tribunal, in giving me guidance on how I should approach such fact-finding exercises, expressly told me that I'm only referring to the evidential burden here, not the legal burden.
I agree.
But unless Mr. Biggs tells us that that's in dispute, so far at least, I have understood the legal position to be undisputed, that the legal burden of proof rests on the Secretary of State throughout.
Yes. Yes.
Now, my next question, Mr. Malik, is this. Has that point been the subject of any judgment from this court? Because if it hasn't, speaking for myself, whatever the outcome of this appeal is, I think it may be helpful if this court actually makes it clear that anyone reading the judicial head note in DK and RK should, as it were, insert the word evidential before the phrase burden of proof in number 1.
Yes. So this court looked at DK and RK twice in Asylum and ACTA.
Yes.
I will not take you to Asylum given the time restrictions, but it may assist to look at ACTA, where I think the point was made clearly. So ACTA is a case that Lady Justice Andrew, I think, referred to when she granted permission, where, of course, she was on the bench and looked at DK and RK. And ACTA is...
Tab 11.
Yes, tab 11. Now, ACTA was a case where the upper tribunal held that the Secretary of State's evidence was not sufficient to meet the initial evidential burden. And the upper tribunal heard no evidence from the appellant and allowed the appeal essentially on that basis, that there is no need for the appellant even to answer the case. The Secretary of State appealed to the upper tribunal. The Secretary of State appealed to this court. And if you look at paragraph 2 of the judgment, you'll see that you see a reference to DK and RK. The appellant argued that, well, DK and RK is not good law. It was wrongly decided because the Secretary of State's evidence was not enough even to meet the initial evidential burden. And if you wish to see what the court said about it, if you go to page 277 of the bundle, you'll see that what was said in DK and RK is essentially approved. So paragraph 30, the court said that DK and RK was not inconsistent with Asylum, the other authority of this court. Paragraph 32, DK and RK is authoritative. And you'll see that a point is made about the evidential burden, that DK and RK essentially said that the evidence was sufficient to discharge the evidential burden. There is a case to answer. So this is what this court said, and you'll see that the appeal was allowed. It was remitted because the tribunal below had made no, the the tribunal below had proceeded on the basis that, well, there wasn't a case to answer. So this is the best that you get,
That's
Lord, is paragraph
helpful,
32.
yeah. So this court has clarified that DK and RK is talking only about the evidential burden of proof.
Yes. I mean, of course, otherwise, and that is clear, of course, from paragraph 32.
Yes.
It's also clear from the way in which the case was disposed of. Of course, if DK and RK was about the legal burden, then there would have been no point for a remittal. The court would have said that, well, that legal burden is established in every case, and the appeal fails.
Yes.
So that is DK and RK.
Speaking for myself, I have to say, I don't know if I know you and Mr. Biggs have been in all of these cases.
Yeah.
So can I just ask for your assistance on? Speaking of myself, I had always understood that in law there is no such concept as a factual precedent. The doctrine of stare decisis, or the doctrine of precedent, is all about principles of law.
Yeah.
So I've always had difficulty, and I think Lord Justice Laws said this in a public law case about 20 years ago.
Absolutely.
I forget the name. You may know the name of the case.
Yes.
I can't remember. But
Yes.
as a general
Yes.
proposition,
Yes.
the law takes the view that a decision is binding for the
Yes.
future only on
Law.
matters of law, not on matters of fact.
Yeah.
And so when in this context there's reference to DK and RK having some precedential value, what is meant by that?
Well,
It doesn't seem to be in dispute, but what I think is being said is that it would be inefficient and potentially productive of injustice if in every appeal before the FTT, the Home Office had to adduce exactly the same evidence
Yes.
time and again.
Yes.
And so is this right, that you can, at least as a starting point, you can start from the proposition that the generic evidence for the Home Office does adduce enough that it needs to be answered by a particular appellant on the facts of a particular case. But does it go any more than that? Does it say any more than that?
Yes. Yes. So the two points that I make in reply. The first is again just with respect is putting forward a point that is against that approach. Now this court has said very clearly that, well, the fact finder must proceed on the basis that the evidential burden is met. Must proceed on the basis.
But where has this court said that?
Now this is what this court said in Majumdar.
Right.
I'll take you to that authority just in a minute.
Okay.
But this is what this court said, and I don't, for my part, argue against it. The second point, Lord, is that I absolutely and respectfully agree that, well, DK and RK and all these cases are decision on facts rather than propositions of law. So the proper course, and I make the point, give that, Lord, you've asked a question, that the proper course is that at the fact-finding hearing, when the appellant tenders himself for cross-examination, the Secretary of State should show the witness, DK and RK, and say that, well, a different tribunal has looked at that evidence and has made these findings of fact. What do you want to say about it? Or your evidence is not credible in the light of those findings of fact. So that is in principle the approach that ought to be applied in fact-finding hearings. So just answering, just taking you to this court's judgment in Majumdar. So it's behind tab 4 of the bundle. And this is paragraph 4 of the judgment, page 76. You'll see a reference to Shazad and Chowdhury, and this court held in that case that the evidential burden is met, and the fact-finding assessment must proceed on that basis.
Right. So this is in fact before DK and RK.
Yes.
So
Yeah.
again, this court has made it clear
Yes.
that the Secretary of State's generic evidence is important, but what it does is it goes to the initial evidential burden of proof.
Yes.
But as you rightly accept, this court has held that although this is an arena where we're dealing with findings of fact rather than propositions of law, nevertheless, the generic evidence does have some precedential value.
Yes.
Because it will be taken to discharge the initial evidential burden of proof in every case.
Yes. But the only point that I with respect add is that, well, it's not the generic evidence alone. So Shahzad and Chowdhury makes the point that, well, generic evidence must be accompanied by specific evidence about the applicant, that his TOEIC scores have been cancelled. So when law refers to generic evidence, or when
I'm only using that phrase because
Yes.
that's what is in paragraph 4.
Yes.
Do you want to show us any other passage that deals with anything else they have to
No,
use?
I mean, this is Shahzad and Chowdhury essentially. So when in a broader sense, the parties refer to generic evidence, that includes not only the sort of generic evidence, but also what is called lookup tool, which is adduced in this case, which shows that
Lookup tools.
lookup tool. Yes,
Yeah.
this is an Excel sheet
Oh yes, yes.
that would show that the test results have been cancelled. Well, if the generic evidence includes that together with the witness statements, and that's enough, I accept. But then, when you have looked at paragraph 4, you will see that, well, that case, Majumdar, was about the evidential burden.
Yes.
Paragraph 5 was actually about whether the evidence was enough to discharge the legal burden. It wasn't. And this court, you'll see that
That's helpful.
the decisions made below were approved, the decision being that, well, the appellants did not cheat. There's just one further authority that I'll take you to, and will then make submissions on facts. And this is the recent judgment, the last test case on the subject, Waki and Joseph.
All right. Where's that?
This is tab 12 of the authorities bundle. And if you look at page 280, you'll see the guidance again given in 6 points. So paragraph 1 makes it clear that, in my submission, that the Secretary of State has discharged. The first point is that the burden of proof is always on the Secretary of State. And then DK and RK is clarified at paragraph 2 that the evidence is strong enough to meet the evidential burden, but will call for a credible explanation. So it is for the fact finder to decide whether the oral evidence given by the applicant is credible.
Right.
So this is paragraph 2. What Waki helpfully does also, if you look at paragraph 4, it lists different sort of frauds that were happening in TOEIC cases. And you'll see that it's direct substitution, remote control, dual monitor, parallel testing, fake identities, mass replacement. But you'll see the point that is made at the end that, well, it's possible that a fraud was happening at a college, but those who were giving tests were entirely innocent. So you'll see that this is the end immediately after paragraph 4, that method D, parallel testing, can operate so that the test taken by a genuine candidate who is unaware of any fraud. So an applicant would go to the test center, would sit for the test himself without knowing that it's not his results that are being submitted, but there is a parallel testing method that is being used because that is more efficient for the colleges, and those results were being submitted.
So the college was doing it presumably for its own advantage, not for the individuals.
Yes, because it's more efficient.
Yeah.
Or mass replacement of files.
Yeah.
That's more convenient. So if you have to deal with 100 students and submit their results, it's more efficient. A college would.
Is that because you can then advertise to the public that we have a 99% pass rate?
Well, yes, that is one of the reasons. Another reason is that, well, perhaps it's more efficient, if I may put it this way, just to have one template and just to submit that template in every single case. But the point that is being made is that it's possible that a genuine candidate would go to a test center, would sit for the test, but who is unaware of fraud and who is not complicit. So this is not to doubt, you may have submissions from other friends, this is not to doubt the chain of custody or to challenge the integrity of the evidence that the Secretary of State has. But the point is that it's possible that, you know, out of those 40,000 people, many were innocent, entirely innocent. That's the reason the courts have said, well, look at the evidence, hear evidence, and then decide whether to believe the appellant or not.
Right.
Now, can I just take you to page 314 of the bundle just to show you why that appeal failed? And if I ask you to look at paragraph 132, you'll see that Waki gave evidence, cross-examined. He said that, well, he took the test in the morning of 21st of May 2012. That was inconsistent with the documentary evidence. Paragraph 134, and this may be a useful contrast with the facts of this case. So he, just shortly before taking the TOEIC test, sat for an IELTS test and failed. But he then took the TOEIC test and passed. And the tribunal did not believe the appellant, said that, well, the evidence was just not credible. So the appeal failed, again, I respectfully emphasize, not because of the strength of the Secretary of State's evidence alone, but because the Waki's explanation was poor. He was not believed. So these are the authorities that I wanted to take you to, and they deal with the approach to be adopted in TOEIC appeals. And I said, what one gets ultimately from these authorities is that the question as to whether a person has cheated is always fact-specific, and the answer will depend on the fact finder's assessment of the oral evidence, whether to accept or reject that evidence. Now, can I then move on to the facts and show you what was before the First Tier Tribunal, before I show you the tribunal's decision itself. So if you look at the appellant's supplementary bundle, this is the supplementary bundle of some 44 pages. And can I take you, milady and milords, to page 23 of that bundle? Now, this is a skeleton argument on behalf of the appellant. Now, this was filed some six months before the hearing. It was settled on 2nd of December 2022. The hearing at the First Tier Tribunal, I think, was in June or July 2022. Settled by an experienced counsel. If you look at page 24, paragraph 5, there is a heading, Schedule of Issues. 3 questions are identified, entirely consistent with the case law. But what is relevant, directly on point, is that if you look at paragraph 6, counsel for the appellant referred the judge's attention to DK and RK expressly, the authority that the Secretary of State says and the upper tribunal says wasn't really taken into account. And there is a concession that the initial evidential burden is discharged. Paragraph 7 concerns the explanation. And then there is a separate heading on the legal burden of proof. Various authorities are referred to. But can I ask you to look at paragraph 13 in particular? This is where you'll see a summary of the appellant's case on the facts. The submission was that his account was clear and consistent. Well, he is a good student. He obtained level 5 qualifications at around the same time when he's accused of being dishonest.
I'm sorry, which paragraph?
So this is paragraph 13, Lord, page 26.
Thank you.
So his evidence is consistent. He's a successful student. So in 2012, 2013, he was actually studying, obtained a level 5 qualifications. So you put that in the context as to whether that person would cheat. And then as soon as he came to the country, he completed an English course, a different course. And then D, he passed an IELTS test, which shows that he is proficient in English, at the relevant time. And the submission is that the legal burden of proof is not met. The date is relevant, I ask Lady Lords to note, is 2nd of December 2021. Some 6 months before the hearing.
Right.
Yes, so the hearing was on 2nd of July 2022. Now, if you then go to page 28, you'll see Annex 1 to the skeleton. You'll see that.
Mr. Malik, my apologies. Which page?
Page 28, the next page, my lady. So Annex 1, this is Annex to the skeleton argument. So basic background facts are summarized. And then, most importantly, if you go to page 30, and this deals with the Secretary of State's point that, well, the judge hasn't really taken into account the relevant case law. Look at Annex 2, Schedule of Relevant Law. This is before the judge. And you'll see that every single lead authority is referred to, in my submission, in an entirely objective manner by counsel who appeared for the appellant. There's reference to SM and Kadir, what I've taken you to, MA, quotations from MA, expert evidence, and then go to page 34, DK and RK, paragraph 8. And the submission is made as to DK and RK, paragraph 9, Majumdar, the authority that I've taken you to, and then case law on the remedy. So the judge had the benefit of this document, which summarizes the law in my submission entirely, accurately, objectively. So the suggestion that, well, the judge wasn't really aware of the law is simply untenable. The next document, page 37, is the appellant's witness statement to give evidence in chief. It's a comprehensive witness statement, but you'll see this is paragraph 11 of the statement. He said that, well, I took the test 8 years ago. I don't remember exactly what has happened, but I remember some details. There were 25, 30 participants. He provides an explanation as to how he traveled to the test center. He took a bus to Mile End. The college was close to the test center. He sat for the exam on the first floor. And then can I ask you to look at paragraph 9 as well? He said that, well, when I went to the test center, they took my photograph. And that photograph that was taken at the test center actually appears on my TOEIC certificate, unlike other cases. So he's emphasizing that I took the trouble to travel to the college. I was good in English, he says subsequently, paragraph 15. I took the trouble to go to the college. They took my test. This is what happened on that day. I did not cheat. There wasn't any incentive for me to cheat. I was good in English. So this is the appellant's evidence. If you wish to see the TOEIC certificate, the actual TOEIC certificate, it's page 41 of the bundle. It has the appellant's photograph. And if you wish to see the evidence of his English language skills at the time, this is pages 43 and 44. He passed an IELTS test in 2010. And in 2013, when he's alleged to have committed fraud in English language test, he was studying for a diploma in business administration and passed that diploma. Now this, and perhaps it's the right time to perhaps to say something more about the point that Milady made. Well, when an advocate is faced with that evidence, a counsel representing the Secretary of State is faced with that evidence, it is for that counsel to exercise a judgment, to decide, well, whether I would want to challenge that evidence, or whether I'm happy that this evidence is consistent, it's consistent with the documentary evidence, and there is no need for me to challenge it. So if counsel or whosoever is representing the Secretary of State exercises that judgment, then that is a matter for them. So the First Tier Tribunal's decision, if I may now take you to that document, this is page 41 of the bundle.
Of the core bundle.
Of the court bundle, my apologies, yes.
Yes, thank you.
So you'll see that the appellant, the hearing was in July 2022. The Secretary of State had the skeleton argument and the witness statement and the evidence.
I see that there was a Home Office presenting officer
Yeah, no,
who
so,
appeared, so not strictly speaking counsel.
no, so Mr. Mopara is actually counsel.
Oh, I see. All right.
Yes, so he's not a presenting officer.
I see. Oh, that's wrong, is it?
That's right. Yes. He's counsel, if I may respectfully say so, an experienced counsel.
Right.
Yeah.
I'll just make a note of that.
But for sort of practical purposes, it makes no difference whether it was a presenting officer or counsel. But just to yes, it's right just to correct the error and to say that
Yes.
well, it's an independent counsel, not an employee of the Home Office,
I see.
but counsel.
Right.
So both sides are represented. There is a detailed summary of the background, but for the relevant purposes, if you look at paragraph 5 of the judgment decision, page 42, the judge there summarizes the Secretary of State's case. The Secretary of State's case on papers, as set out in the decision, that the TOEIC test was fraudulent, it was invalid, and it was fraudulently obtained, and that is the reason the Secretary of State refused the application. So the judge knows what the Secretary of State's position is on paper. Now, if you then go to paragraph, paragraph 12, which is wrongly referred as paragraph 2, which is on the next page, page 43, you'll see what has happened. So after paragraph 9, there is a glitch in the Word document that the judge was using. So instead of 10, the document starts at 1 again.
So probably it should have been 11, but it doesn't matter.
Should have been 12 because there is 1 immediately after 9. Yes, 11. My apologies. Yes.
No, that's all right.
Yes, of
So
course.
we know what we're talking about. It's the bottom paragraph on page 43.
Yes.
Right.
So this is the paragraph where, well, after setting out the Secretary of State's case, the judge summarizes the appellant's evidence and submissions. There's a witness statement, evidence of previous English language qualifications. He passed all the exams. He'd progressed well in the education. And his health conditions and so on. So this is the sort of summary of the appellant's case. If you then go to page 44, you'll see a heading, the hearing. I heard oral evidence from the appellant, the judge says, who gave evidence before me in English. He adopted his witness statement as part of his evidence in chief. He provided evidence in relation to the circumstances in which he took the test. He established a private life in the country. You'll see that there is no reference to cross-examination. The reason being that there was none. You'll then see submissions. Of course, submissions are not summarized in the decision, but I took you to the submissions made by the appellant. I'll say nothing about the submissions that the Secretary of State made unless you want me to tell you what those submissions were.
Was there a document from the Secretary of State?
There was a document which is of no assistance whatsoever. If you want, I can show you that document now. So this is...
Do we have it?
Yes, so in the Secretary of State's supplementary bundle, so what happens, so there is a document called Respondent's Review but it says nothing.
The final document. is
Final
the-
document, page 71. Well, it says nothing of significance.
Sorry, which page is it?
So this is the Secretary of
yes,
State's
71.
bundle.
71, yeah.
71. Yes. This document is not dated.
So it doesn't look like what I would call a skeleton argument.
No, but under the practice direction, the respondent's review is meant to be a skeleton argument.
That's not a criticism.
No, but
It's that it doesn't
No.
have, for example, the reference to the case law,
No.
which the skeleton argument for the appellant did have.
Yes, exactly. So the judge had the benefit of the detailed submissions that the appellant made in writing. Now, if Miller and Friend is going to invite you to find that, well, the findings of fact are perverse, the judge hasn't dealt with X, Y, and Z, in my respective submission, he will need to show you where those points were made to the judge.
That didn't, forgive me, that didn't feature in the upper tribunal's reasoning.
No.
So I think for now at least, I think we would be most assisted by hearing your appeal, as it were,
Yes.
as to why the upper tribunal is
Wrong,
wrong.
yeah, absolutely, yeah. So, and you'll then see a heading decision. This is where you have the relevant findings of fact. If there is an error in the decision, it is at paragraph 7. But that error is in the Secretary of State's favor. Last sentence, in relation to the allegation of fraud, the burden of proof moves to the respondent. If this is met, the burden of proof reverses to the appellant. That's obviously wrong. The appellant had no burden of proof, but the judge proceeded on the basis that it was for the appellant to prove his innocence. An error that he made in the Secretary of State's favor. The judge refers to the relevant decision, the decision in Kadir, and says that I find that the evidence produced by the respondent is sufficient to meet the initial burden. That's the evidential burden.
Yes.
Consistent with what this court has said. The judge, of course, knows that the evidence is strong enough so to require an explanation.
And I think you would submit that in that sentence, the judge has encapsulated what the upper tribunal had said in DK and RK,
Absolutely.
and that DK and RK is not authority for anything more than that.
Yes.
And obviously, we'll hear what Mr. Biggs says in response to this, but I think what you're submitting is that if the judge had put, as it were, as well, not only a reference to Kadir, but had said expressly, I've also had regard to the case of DK and RK,
Yes.
the upper tribunal, Judge Perkins, could have had no reason to complain about this.
And my Lord will recall that when I commenced my submissions, I took you to Ulla, where Lord Justice Green summarized 6 principles. Principle 5 was that judges are not required to refer to the case law. One should proceed on the basis that they are aware of the authorities. They are not required expressly to refer to each and every authority. So if you refer, for example, to DK and RK, then why not to MA, or why not to Wasson, or why not to Waki? So the point essentially is that, well, this court must proceed on the basis that the judges are aware of the relevant authorities. But there is, of course, a further point that I make, which is that you can be absolutely certain that the judge knows about DK and RK because he received submissions from the appellant on that. Now, and then see how, so that paragraph is entirely consistent with DK and RK. Again, if there is an error, it is perhaps is in the last sentence of paragraph 8. The judge says that, well, the appellant has met the evidential burden of demonstrating that he took the test himself. So the judge proceeds on the basis that the appellant has to prove his innocence, and he says that, well, I'm satisfied that he has, although the appellant had no such burden.
Yeah, I think that he's just saying what he'd said at the end of paragraph 7. the burden of proof shifts, and he's clearly referring to the evidential burden, expressly does so there.
Yes.
But in any event, I think you would submit again that if there's been an error, if anything, it's in favour of the Secretary of State.
Yes.
Right.
Now the judge could have stopped, in my respectful submission, could have stopped at paragraph 8 and could have simply said that the appellant's evidence is not challenged and I'm allowing the appeal. But what he does is that he critically, objectively evaluates the appellant's evidence in any event. And that is the reason there being no cross-examination is not at the forefront of my submissions. But if you look at paragraph 9, the appellant has been, he came here, the judge says, to pursue higher education. The judge refers to the evidence as to what happened after the TOEIC exam. No college would offer a certificate of sponsorship. The appellant has undertaken English language courses previously, passed the IELTS test, undertaken courses at level 5. He had already passed a level B1 qualification in English prior to entering the UK, and he took a foundation course. And then paragraph 9, the appellant provided details of attending the test center and taking the test. So unlike some other cases, it's giving clear evidence as to how it traveled to the test center, what happened at the test, and the judge accepts that evidence. Now, the judge, again, could have allowed the appeal there and then, but he then goes to paragraph 10 and refers to the fact that he has taken other English language qualifications. And this is important, given one of the points that Miller and Friend made. So the judge is not saying that I'm allowing this appeal because the appellant has passed other English language tests. The judge is saying, I find this to be indicative, nothing more than that, indicative of the fact that the appellant took the test himself, indicative. And as I sought to demonstrate, this is plainly a relevant matter, a matter that the judge was entitled to take into account. The appellant had no need to rely on falsified test results or use a proxy test taker. I find that this adds further to his credibility. So he's not treating that factor, as Miller and Friend may say, as determinative. He's saying, well, this is indicative. This really adds on to his credibility as a witness. Paragraph 11, the judge says, well, quite apart from the English language qualification, he completed a level 5 diploma at the same time when he's said to have sat for the fraudulent test. And I find this to be further indicative of the fact that the appellant took the TOEIC test himself. Not that I'm allowing the appeal on that basis alone, but he's adding various points, a classic, and in my respective submission, a good fact-finding assessment. And then he deals directly with the appellant's oral evidence. The appellant gave credible and logical explanation of why he chose the test center. He described attending the test center on multiple occasions in order to take the test. I find the appellant's evidence to be compelling and further indicative of the fact that he took the test himself.
So what the judge is doing is reviewing the factual evidence, the unchallenged factual evidence that is before him, and then identifying what he derives from that evidence.
Yes.
Which is very much a stepping process, isn't it, as part of fact-finding?
Precisely so. Classic fact-finding. As I said at the outset, with respect, there's nothing remarkable about this exercise. Judges do that exercise on a sort of daily basis. But he hasn't. The point that I'm emphasizing is that he isn't allowing the appeal simply on the basis that, well, he was proficient in English. If the judge had said that, that could have been objectionable, because people do, a person who is proficient in English may cheat for a variety of different reasons. But this is one of the many points the judge made. Paragraph 13, the respondent hasn't given adequate consideration to the evidence. And you then have a reference which comes as an afterthought, essentially at paragraph 14, where the judge says that, well, where the judge refers to APPG report. Now, I mean, this is simply an additional comment in my respective submission. And what the judge says about that report, I don't think is controversial. But I would accept that if the judge had allowed the appeal on the basis of the APPG report, then that would have been objectionable. But he simply records what the APPG report says. But this is simply an additional point that the judge makes. And I suspect my learned friend would say that, well, the judge should not have looked at the APPG report at all. If my learned friend makes that submission, then that would be a wrong submission. Of course, this is the evidence. If my learned friend says that, well, the judge should have looked at that report, or but together with all other evidence, together with the findings made in DK and RK, that's all fine. I don't have an issue with that.
Right.
But
If the judge had said, I've further had regard to the evidence given to the APPG, would that have been objectionable?
No, no. But I do respect, absolutely. But I do invite my lady and my lords to just consider the relevance of the word further. So this is an additional point, a point that is in addition to the points that the judge has already made. And the judge is saying no more than simply having regard to that report. Having regard to that report is not sort of making a factual finding or allowing the appeal on that basis. He believes the appellant, he allows the appeal. This is paragraph 15. So one may disagree with the judge, one may disagree with the way in which the judge has expressed himself, can criticize the judge for getting the paragraphs wrong. But these findings are open to the judge.
Just have an eye on the clock. How much longer do you need?
Just five more minutes. I'll show you the upper tribunal's decision, and that's it. I spoke to my learned friend about the timing. I think my learned friend may need an hour or so. So I'll only need 5 minutes at the end just to consider any reply. So the upper tribunal's decision. This is page 28 of the bundle. And the relevant part of the decision is paragraph 26 onwards, essentially. So if you look at page 31, this is paragraph 26. This is where you actually get to the reasons given by the judge.
Yes.
So the decision in DK and RK is not determinative. And this is the end of paragraph 26, the first point the judge made. I'm not sure if the judge in that paragraph is giving a compliment to my advocacy or there's a criticism. But the point is that the judge is saying that, well, the upper tribunal is saying that the judge was obliged not only to make clear conclusions, but give some indication of how conclusions were reached. Well, he did. He did give an indication as to how the conclusions were reached. So the point that is made there is with respect a bad point. You then have two further points at paragraph 27, and those points are wrong in law. The judge says that DK and RK shows that the burden or hurdle that it is for the appellant to dislodge the presumption of dishonesty. This is wrong at every level. First, there is no burden on the appellant to dislodge anything. The burden of proof rests on the Secretary of State, and there is plainly no presumption of dishonesty. You go to the fact finding with an open mind, not with a presumption that a person is dishonest, and it is for them to dislodge that presumption. But if I may respectfully add, as I said, the judge below, in fact, assumed wrongly that the burden was on the appellant. The judge has not explained how he reached the conclusions he did. The judge did explain that. You disagree with those findings, but you cannot say that the judge has not explained how he reached those findings. If you then go to the next page, page 32, that there was no need for the claimant to cheat, and I'm not sure with respect what the judge is saying, but the point is that, well, the fact that you had no incentive to cheat is not enough, but that surely is a relevant factor, one of many factors. And then good character is not a defense to a criminal charge. I mean, no one says that good character is a defense to a criminal charge. Of course, good character is a positive matter that fact finder takes into account in assessing credibility of the evidence, just given that the judge has made a reference to criminal proceedings. So Milady Milord knows that, well, good character is not a defense, but you do give direction, good character direction, that, well...
Normally, the defendant of good character is entitled to that direction.
Absolutely. So the direction, as Milady Milord knows, is that, well, good character is not a defense, but it's a positive feature that you take into account in the appellant's favor when considering whether to accept his evidence. And secondly, the fact that a person hasn't done something bad makes that person less likely to have cheated. The point...
Second limb, isn't it?
Second limb. So this is the point that the upper tribunal was making in SM and Kadir and this court, that, well, you look at the person's character, you look at the cultural environment in which he operated. So if you have an appellant who has previously breached immigration conditions, previously breached immigration law, or was involved in other kind of fraud, or wasn't a genuine student, then you take that against the appellant. But if you have someone of good character, then that counts.
I think what my lady, if I understood her point correctly, is referring to in the second limb is that it goes to credibility.
It goes to credibility, absolutely.
Yeah, so in a criminal trial,
yes,
you absolutely have to give both limbs of those directions,
yes.
Usually.
Yes, yes. So I'm not suggesting that because the appellant is of good character, he should be believed in this context, but that is a factor that is relevant. And then finally, paragraph 28 of the upper tribunal's decision, the judge says the problem is that the claimant's results are unreliable, and in absence of persuasive explanation, it is very hard to avoid, and a proper explanation has to be given. I mean, this with respect is a sort of classic disagreement with the findings of fact. So whether or not there is a proper explanation, a persuasive or credible explanation, is for the fact finder. The upper tribunal cannot intervene simply because they take the view that the explanation is not persuasive or credible. You've got to leave it to the fact finder who hears the live evidence. And absent perversity or irrationality, as the case law makes it plain, there's no basis to interfere with it. So in truth, the reality is that neither the Secretary of State nor the upper tribunal was happy with the findings of fact made by the upper tribunal.
Mr. Malik, can you just remind me of how the Secretary of State formulated the ground of appeal before the upper tribunal?
Yes, it's page 38 of the bundle.
Yes, thank you very much.
Page 38, the ground is that the judge failed to apply the principles in DK and RK.
I see.
And then last paragraph, it is unclear whether the judge was even aware of DK and RK. But surely he was.
Thank you very much.
So it's no error of law. The upper tribunal set aside the decision simply because the upper tribunal wasn't happy with the findings of fact. So for these reasons, in my submission, the upper tribunal had no power to order a rehearing. This appellant, as I said,
Well, that's very clear.
at the commencement, he spent 7 years trying to clear his name from 2015 to 2022. He received a fact-finding hearing in 2022. We are now in 2024. The allegation is about something that had happened in 2023. I mean, this, in my respective submission, the right course of action for the court is to set aside the upper tribunal's decision, restore the decision made by the First Tier Tribunal. So unless I can assist you any further, these are my submissions.
No? Good, thank you very much. Yes, Mr. Biggs.
Thank you, my lord, my lady, my lord. Can I first deal with my learned friend's brand new point about the absence of cross-examination? I say it's a brand new point because it's not a factor that was, as I understand it, raised before the upper tribunal. And furthermore, it's a factor that seems to have been explicitly disavowed or is inconsistent with the position that was taken by the appellant in the skeleton arguments filed in this court. So at paragraph 5 of the replacement skeleton argument and paragraph 5 of the appeal skeleton argument, which is page 16 of the core bundle, I think both paragraphs are identical. It's asserted, and I'm quoting, in the second sentence,
Yes.
the appellant gave oral evidence and was cross-examined. So this is not a point that I've come to the court prepared to deal with. And on that basis, in my submission, it's unfair and inappropriate for my learned friend to rely upon it now. I should say, though, to be fair, that since the point was raised, we have made inquiries. I have seen a note prepared by counsel in respect of the hearing below, and the note asserts that there was no live evidence at all. That's the language of the note. Now that it appears to be inconsistent with what the First Tier Tribunal said, as I think paragraph 3, that there was oral evidence, and indeed the First Tier Tribunal doesn't mention one way or the other the absence of cross-examination. So because of the way this point has been raised, I'm a little uneasy to get into it, frankly, but that's the information that I have.
That's helpful, Mr. Biggs. Certainly speaking for myself, my understanding is that this is not featured as the mainstay of Mr. Malik's submissions before us. He relies on other points.
Yes.
And certainly doesn't rely on this as being dispositive in his favour. So I think you can proceed on that basis.
I'm very grateful. I should just also point out, by reference to the note that I've seen during the course of the hearing, that it is very clear that the Secretary of State, in a sense, challenged the appellant's evidence because in submissions, the decision under appeal was relied upon in full, and that decision clearly took the position that the appellant had cheated on the TOEIC. And so whether or not there was cross-examination, whether or not there was oral evidence, it was very clear before the FTT that the Secretary of State's position was that this person had cheated for the reasons summarised in the reasons for refusal letter.
Yes.
Can I turn to deal with the correct approach on appeal in respect of a challenge to an expert tribunal? There is not a dispute between the parties on the relevant principles. My learned friend has very helpfully referred, if I may say so, referred the court to paragraph 26 of this court's decision in Ulla, where the relevant principles are summarised. And we certainly don't suggest that there's anything at all in dispute between the parties as to those principles. What we do submit, though, is that those principles do not provide a complete answer for the appellant. This court has extensive experience of cases where the First Tier Tribunal and indeed the Upper Tribunal, despite being expert tribunals, have erred. And what's necessary is that the court looks at the totality of the reasoning deployed by the tribunals in the relevant context, having regard to the relevant legal principles, to ascertain whether something has gone wrong, albeit paying proper respect, if I can put it that way, to the expertise of the tribunals. We would also point out that the principles my learned friend emphasises in paragraph 26 cut to a degree at least both ways, because they also inform this court's approach to my learned friend's challenge to Upper Tribunal Judge Perkins' reasoning. and I'll come towards the end of my submissions to Upper Tribunal Judge Perkins' decision, we accept, and I hope I'm not being unfair to Judge Perkins, who's an extremely experienced and careful judge, we accept that the reasoning is perhaps less than ideal, but we do submit that, bearing in mind the principles in ULA that my learned friend emphasises, there is insufficient basis to conclude that Judge Perkins erred in law, in concluding that the First Tier Tribunal erred in law. Before I move away from this topic, I should also point out that the restraint, if you like, that this court normally shows to the decision of an expert tribunal on the basis that the expert tribunal can, for example, be assumed to understand the law and to understand what needs to be considered by it, again cuts against the appellant's position to the extent that my learned friend relies on the suggestion that at various points were not put to the First Tier Tribunal in respect to the allegation of TOEIC cheating by the Secretary of State. He suggested during the course of his oral submissions that it was necessary for me to show that each point we rely upon in a respondent's notice was put in terms to the First Tier Tribunal judge. In my submission, that is not required, bearing in mind that the First Tier Tribunal is an expert judge and must be taken to know what is relevant and what authorities need to be considered and applied. So, can I turn to deal with the status of DKNRK number 2? A point that was canvassed during the course of my learned friend's submissions.
Yes.
In my submission, DKNRK number 2 is authoritative in that it provides authoritative guidance that must be taken into account by First Tier Tribunals. Part of the function of the Upper Tribunal is to provide guidance on commonly reoccurring issues. That's something, and I don't propose to take the court to the authority, but that's something that Lord Carnworth had in mind and said a little bit about in the Jones and First Tier Tribunal case, which we have in the authorities bundle. At tab 2, page 7. As I said, I don't propose to invite the court to look at it now, but if the court is interested, it's paragraphs 41 to 47 on pages 22 to 23 of the authorities bundle.
Thank you.
Where Lord Carnworth observed, without reaching any firm conclusions, that one of the functions of the new tribunal system, the new Upper Tribunal, was part of the new tribunal system. It was relatively new at the time of the Jones case, was that the Upper Tribunal would provide guidance in order to ensure a degree of consistency and efficiency in respect of decisions taken by the First Tier Tribunal. And that, in my submission, is the territory that we are in respect of DKNRK number 2 and like authorities. But my lady, my lords, we don't need to spend too much time on this because helpfully this court has clarified the significance of DKNRK number 2 in the ACTA case, which is behind tab 11, beginning on page 271 of the authorities. It's paragraph 29, page 277. And I think I will ask the court to turn that up. And just remind itself of that passage.
Sorry, which tab is it?
It's tab 11.
Yes, thank you very much.
Did you say paragraph 29?
Paragraph 29, page 277.
Yes. Oh, yes, we looked at this earlier.
I think we probably did. Also relevant is paragraph 32, mentioned in my skeleton on the following page.
Yes.
So in ACTA, this court rejected the submission that effectively DKNRK number 2 has no precedential value. I think the expression in the beginning of paragraph 29 is no precedential authority.
Yes, it's more the word authority that
Yes. Well,
I'm
perhaps that's
I'm
why
not sure.
intuitively I moved away from that.
I'm not
in
sure I
my-
would have used that word myself, but it may not matter.
Yes,
Value, I can certainly see your point.
yes, I'm grateful. The way I see this, for better or worse, is that there's at least an analogy with the upper tribunal's authority to make country guidance cases. The analogy is just an analogy, but it is well established in that context
Yes.
that the upper tribunal's assessment of factual issues is binding on First Tier Tribunal judges and indeed other upper tribunal judges, unless there is sufficient evidence to dislodge those findings, if I can put it respectfully like that. And in my submission, essentially the same approach applies in respect of DK and RK number 2.
Yeah, Ms. Biggs, that's a proposition I'm familiar with, but without taking time on it now, could you give us a reference to that,
Yes.
if necessary, in an email to our clerks after this hearing finishes? I don't want you to take up time now.
I'm very grateful. Well, I did
Because one of the reasons I ask
Mm.
is that I wonder in my own mind whether Judge Perkins may have had that line of reasoning in mind when because he used the word dislodge, for example.
He did. He may well have done, and if he did, that was unobjectionable.
Right.
I did anticipate that this might be something the court would be interested in, so I've included a relatively recent upper tribunal decision on the significance of country guidance cases.
Right.
It's a case called Rober,
Oh yes.
and it's at tab 10,
Thank you.
at page 213, and the relevant passages exploring the significance and nature of country guidance begin at paragraph 11 on page 218, and it may be that paragraphs 15 to 18, which are on pages 219 to 220, answer my Lord's question.
Yeah, thank you very much.
So that's the nature and status of the guidance given in DK and RK number 2. I should also just at this stage point out that DK and RK number 2 was the subject of a head-on challenge in relatively recent litigation that resulted in the Varkey and Joseph decision that my learned friend took you to. That's at tab 12, page 279. I don't ask the court to turn it up now, but the short headline is that head-on challenge, which focused on evidence of secret rooms being used to perpetrate fraud at test centres, and the implication that someone attending a test centre wouldn't have known that fraud was going on, which is a highly significant factor, as we'll come to see by reference to DK and RK number 2. That challenge failed, and the guidance given in DK and RK number 2 was roundly endorsed, including in respect of the burden of proof, which I'll come to. So, can I now turn to deal with DK and RK number 2? I want to extract from DK and RK number 2, which is at tab 9, page 175 and following, 6 propositions that are relevant to this case. And there may be other aspects of the decision that can be seen, but I want to extract 6 propositions. The first of those 6 is that the burden of proof does not shift. And indeed, the upper tribunal in DK and RK number 2 was careful to explain what the nature of an evidential and legal burden is, and to provide significant guidance on that topic. Can we turn to paragraph 47 of the decision in DK and RK number 2? That paragraph is on page 188. And the relevant paragraphs are paragraphs 47 to 54. In the interest of time, I'm not going to ask the court to read them all now.
No.
But in my submission, in those paragraphs, the upper tribunal very carefully analyses how the burden of proof functions in this type of case, and what the evidential burden is and how it works. at paragraph 50, it notes that confusion can be caused by the fact that the phrase "the evidential burden" appears to be used in two different senses. One where the evidential burden lies on a party who does not have the legal burden of proof, and the other, mentioned at paragraph 51, where the evidential burden is said to lie on the party that has the legal burden of proof. And in that latter case, which is relevant in respect to the Secretary of State's evidential burden here, what the upper tribunal explained at paragraph 52, I think, perhaps 53 as well, is that the evidential burden means that essentially you have to show a prima facie case such that if your case is not answered by countervailing evidence, it would prove the thing in issue, the fact in issue. And that, in my submission, is the sense of the evidential burden that is relevant to the judicial head note that my learned friend was asked some questions about, because it's that type of evidential burden, if you like, that is on the Secretary of State in these TOEIC cases. So what the upper tribunal pointed out in DK and RK number 2 is that the Secretary of State's evidence is amply sufficient if it is not adequately addressed by evidence from an appellant who's accused of TOEIC cheating to prove fraud. But what the upper tribunal is also very clear about, and this is salient to the FTT's reasoning, which I'll come to, is that there is no shifting of any kind of either a legal burden or indeed an evidential burden. And you see that in paragraph 53. Evidential burdens have, however, this in common with the burden of proof: they do not really shift. So that's the first proposition. Burdens of proof do not shift, and you've got some very helpful and careful guidance on the nature of an evidential burden in this context, given in DK and RK number 2. Second proposition that we get from DK and RK number 2 is that the respondent's evidence is substantially reliable. By the respondent's evidence, I mean, and here there's an ambiguity, I think, in some of the cases, the generic or general evidence of widespread cheating and how cheating is detected. So that includes the evidence from Peter Millington and Rebecca Collins, which we have in the supplementary bundle filed by the respondent, as well as specific evidence against a particular individual from ETS, essentially confirming that their particular test has been flagged as an invalid test. And what that means is that ETS has detected the use of a proxy test taker. So the upper tribunal in DK and RK number 2 concluded, moving away from the position in SM and Kadir, that the Secretary of State's evidence establishing fraud that's routinely produced in these cases is reliable, is substantially reliable as a matter of generality. And we see that in particular at paragraphs 103 to 107. Those passages begin on page 204. Sorry, 204.
203 and 204.
Yes, I'm so sorry. No, I did get the reference wrong. Page 203.
Yeah.
Going over leaf.
Pick your reference for it.
Paragraphs 103 to 107.
Yep.
And here, the upper tribunal was careful to differentiate between two, if you like, forensic questions. The first is, and this was the focus of the early TOEIC litigation, were the voice recognition processes used to detect a proxy reliable? That's dealt with at paragraph 103. The second forensic issue, which is now almost always the focus in these TOEIC cases, is the question of whether the voice record that is analysed by ETS's voice recognition processes is linked or reliably linked to the person accused of TOEIC cheating. That point is called continuity in the authorities, and that's the word used in paragraph 104. But in respect of both forensic issues, the upper tribunal is very clear in the passages I've referred the court to, that there is absolutely no reason to think that the Secretary of State's evidence is unreliable. And in the instant case, it's that linkage or continuity issue which is front and centre, because as I'll come to show the court, the appellant accepts that he requested a copy of the voice recording that said to show that he used a proxy. He obtained that recording, listened to it, and he says that his voice is not on it. And I flagged that at this stage, and I'll come back to this, because Lady Justice Andrews, when granting permission, I think mistakenly thought that the appellant was somehow unable to obtain that voice record. That was not his evidence, and that may be significant. The third proposition that I take from DKNRK number 2 is that the APPG report and the expert evidence summarised in it in no way is relevant to a challenge to the respondent's evidence, or to put it another way, does not undermine the reliability of the respondent's evidence. We see the conclusion on that topic at paragraph 92 on page 200. This is the concluding paragraph that earlier paragraphs set out the tribunal's reasoning. The court at paragraph, the tribunal in DKNRK number 2 is absolutely clear in paragraph 92 that there's just nothing, there's nothing in the expert evidence given to the APPG, as summarised in the APPG report, or apparent from the transcripts that were produced in DKNRK number 2, that undermine or substantially undermine the evidence produced by the Secretary of State. And we say that and I'll come back to this, that conclusion in DKNRK number 2 is just clearly and obviously, with great respect, inconsistent with what the First Tier Tribunal judge says. And I think my learned friend came close to accepting that. He seeks to minimise that aspect of the First Tier Tribunal judge's reasoning. We say that aspect of the First Tier Tribunal's reasoning cannot be minimised, and it clearly indicates that the First Tier Tribunal judge just didn't properly understand DKNRK number 2. The fourth proposition, my lords, my lady, is that English proficiency, evidence of English proficiency, does not, certainly not necessarily, support a response to the Secretary of State's evidence of fraud. That is very clearly set out at paragraph 108, DKNRK number 2, on page 204 of the bundle. Uh, 204 going over. And it's the latter part of the paragraph in particular, on page 205.
Yeah. Can you, just as a matter of common sense, can you give us a headline? They say there are numerous reasons why a person who could pass a test might nevertheless decide to cheat. Just give me the best example that you're aware of.
Well, it's hard for me to get into the right mindset, but frankly, there are two that spring to mind.
Right.
One, convenience. You don't have to worry about having to sit the test. You're guaranteed a pass. It might be the case that you can get the result fairly quickly, but certainly convenience is an obvious point that comes to mind. Secondly, people may be caught up with the fact that people in their group, their friend circle, are behaving this way, and they may do it for that reason. And the way that this point is expressed at paragraph 108 is robust in my submission. What I mean by that is the tribunal is very clear that it must not be thought that the fact that someone had adequate English to pass the test themselves constitutes corroboration for their evidence of having genuinely sat the TOEIC that's impugned. So the point that's being made here is not that this is a factor but shouldn't be given any substantial weight, although that's perhaps one interpretation. The point is being put in a more robust way. But be that as it may, in my submission, any first tier tribunal judge that thinks that the evidence before them indicates that an appellant didn't have a motive to cheat because they could have successfully taken the test themselves without cheating, any first tier tribunal judge that's thinking that that is significant would have to deal in terms with this very clear guidance in DKNRK number 2 at paragraph 108, even if it would be open to a judge of the first tier tribunal to say, well, as a matter of common sense, I think this is a relevant factor. Because this is part of the guidance given by the authoritative decision in DKNRK number 2, and a first tier tribunal judge who's aware of that guidance would know that they need to deal with it, otherwise they'll risk an appeal. Fifth proposition, the tribunal in DKNRK number 2 was very clear that it is now overwhelmingly likely in a so-called fraud factory case that where there is the usual evidence that a TOEIC test is invalid, i.e. that proxy was used, the person who is the subject of that evidence cheated. Overwhelmingly likely that in a fraud factory case, the person cheated in the light of the Secretary of State's usual evidence. That is explained very clearly at paragraphs 119 to 126, which begin on page 207. I don't invite the court to go through all of those passages now, unless the court wishes to do that. You get the expression overwhelmingly likely in, I think, the third line of paragraph 119.
Yes.
And so what that means is that one inevitably significant consideration that a first tier tribunal judge must have regard to in cases like the instant case is whether the person who cheated attended a fraud factory. Because if they did, the upper tribunal is very clear that it's overwhelmingly likely, if there's the usual evidence of fraud, which there is in this case, that the relevant appellant cheated. And this is the point I have in mind in my skeleton argument when I say that the forensic landscape has shifted from the position at the time of the early cases, in particular SM and Kadir, where the upper tribunal expressed scepticism about the reliability of the Secretary of State's evidence, concluding that the evidential burden on the Secretary of State was only just passed. Now, especially in a fraud factory case, the upper tribunal is clear that the evidence is actually very strong. And just to be clear about this, that proposition has been endorsed in the Varkey and Joseph case, so the proposition that it's overwhelmingly likely in a fraud factory case that the usual evidence of cheating establishes that there is cheating. That proposition's been accepted in the Varkey and Joseph case. It's also been accepted by this court in a case that's not in the bundle but is mentioned in Varkey and Joseph, a paragraph 110 on page 309 of the bundle. A case called Ram in the Secretary of State for the Home Department.
Oh, yes.
It doesn't really add a great deal, so we haven't included it in the objections, but you have the relevant or key passages set out at paragraph 110 in Varkey, page 309. The sixth and final proposition is that even if the case is not a fraud factory case, the upper tribunal is clear in DKNRK number 2 that the Secretary of State's evidence is still strong, essentially, of cheating, still strong evidence of cheating. That follows because of the upper tribunal's observations about the general reliability of the Secretary of State's evidence in respect of those two forensic issues that I discussed earlier. And we see that in the general guidance given by the upper tribunal at paragraphs 126 to 130. On page 209. And on that basis, at paragraph 129, the upper tribunal makes the point that given the Secretary of State's strong evidence, a mere assertion of innocence or ignorance, mere assertions of ignorance or honesty is the language used, by those whose results are identified as obtained by a proxy are very unlikely to prevent the Secretary of State from showing that on the balance of probabilities, there's cheating. So that is an observation about the legal burden. So those are the 6 propositions that I want to highlight in respect of DK and RK number 2. And before I move away from DK and RK number 2, we accept that TOEIC cases remain fact sensitive in the sense that, and this I think must be with great respect, common sense and in accordance with first principles, we accept that a first tier tribunal judge has to look at the totality of the evidence before them and make findings in the light of that evidence, bearing in mind that the Secretary of State has the burden of proving that a person has cheated on a TOEIC. But that does not mean that DK and RK number 2 is not a highly significant legal landmark in recognising that the Secretary of State's evidence is much stronger than the earlier authorities thought it was, and in providing other relevant guidance.
Yes. For example, at paragraph 128, where they draw a contrast with, and indeed disagree to some extent from what had been said in SM and Kadir. And I think at the heart of your submissions is that in our appeal, the FTT referred to Kadir, but made no reference to DK and RK.
Yes.
And that's not just a failure to mention something. I think you say that that's a failure to grapple as a matter of substance with the points that you've been advancing in the last few minutes.
That's right. Those 6 points, which are all salient, and I'll come to explain how they're salient. And it also answers that point that the judge cited SM Kadir without, in terms, or implicitly we say, recognising that the forensic landscape has shifted. That point also undermines my learned friend's reliance on paragraph 8 of the First Tier Tribunal's decision as somehow indicating that the First Tier Tribunal was aware of DK and RK number 2, because the judge points out that the burden of proof is on the Secretary of State and works in a certain way. That had been established in SM and Kadir, and indeed in the Majumdar case, which was the decision of this court on appeal from SM and Kadir. And so that was all established long before DK and RK number 2. So that can't assist my learned friend at all. So, my lady, my lords, can I turn to deal then with why we say the First Tier Tribunal clearly failed to properly understand and sustainably apply DK and RK number 2. The first point here that I want to make is that the First Tier Tribunal simply failed to consider whether the appellant attended a fraud factory or not. As I've already submitted, that is inevitably a relevant, indeed very important factor that a First Tier Tribunal judge will have to grapple with in the light of the state of the authorities following DK and RK number 2. Now, my learned friend indicates that there was no evidence before the First Tier Tribunal that suggested that the appellant attended a fraud factory. We don't accept that. The first point to note here is that the appellant attended Eden International College, which was one of the 2 colleges investigated by the BBC Panorama programme that uncovered TOEIC fraud in the first place. And this is mentioned in SM Kadir at paragraph 14 on page 31 of the authorities. in the quotation from a case called Ghazi. It's paragraph 7 of the quotation.
Sorry, which paragraph of SM and Kadir?
Paragraph 14, my lord.
Thank you.
Page 31.
And it's citing.
Citing Ghazi, which
Yeah.
I'll need to double check. I think Ghazi was a case involving Eden College. But in any case, you have paragraph 7 set out in around the middle of page 31 from the Ghazi decision.
Yeah.
And you can see there that Eden International College was identified as one of the two colleges that was investigated by the Panorama programme. So an expert judge of the First Tier Tribunal should have known that. Indeed, it's meant paragraph 14, page 31. Paragraph 7 of the quotation. The second point is that the evidence before the First Tier Tribunal judge clearly indicated that Eden College was a test centre at which a very large number of fraudulent tests were being undertaken. That's very clear in my respectful submission from the what I call the global lookup tool entry. I'm not sure what the Home Office word or term would be for it, but it's a component of the lookup tool that looks at the general situation at a test centre on the day in question. That day in question is the 19th of February 2013. You can see what I have in mind at page 6 of the respondent's supplementary bundle. This was in evidence before the First Tier Tribunal. Everything in the respondent's bundle was before the First Tier Tribunal.
So you could give us a page.
I did. It was page 6, my lord. Page 6 of what you might call supplementary bundle 2 or respondent supplementary bundle. So if we just contextualise this, if we go back a page, you'll see the lookup tool in respect of this appellant. It identifies the test centre as Eden College International, test date 19th of February 13, gives his scores, gives the certificate number, which is the same certificate number we have on the certificate that my learned friend includes in his supplementary bundle. Which again was in evidence before the First Tier Tribunal. And then on page 6 we have a sort of summary of the general position at the test centre on the day in question, 19th of February 2013. And you can see in that row 1 from the bottom under status and count, 83% of the tests taken on that day were invalid. Now what that means, and there can be no dispute about this, what that means is that there was evidence of a proxy tester in 83% of the tests taken on the day in question. In other cases, the fact that there's a large number of questionable tests as well as a percentage of invalid tests has been taken to indicate a fraud factory, as I understand it, but here the vast majority of tests taken at the test centre in question involve direct evidence of dishonesty. So we submit that this, coupled with the guidance in DK and RK number 2 and the observations in SM and Kadir about Eden College, meant that a judge who was aware of DK and RK number 2 would be acutely conscious of the need to consider whether the appellant before them, this appellant in this case, attended a fraud factory. Because as I've submitted, if he did, the Secretary of State's evidence was overwhelmingly likely to prove fraud. Albeit that there would still need to be an assessment of the appellant's response to that evidence. We don't see any mention of that at all, that question of whether the appellant attended a fraud factory, and if so, what its implications are, in the First Tier Tribunal's decision. Second point, the First Tier Tribunal has clearly erred in its approach to the appellant's evidence of having requested and having obtained voice recordings that do not contain his voice. So I think it's now time for us to turn to the First Tier Tribunal's decision. That's in the core bundle, and I think page 41, and the relevant paragraphs, so paragraphs 8, 13 and 15, they begin on page 44.
Yes.
Now I'll come back to what's said about the burden of proof in paragraph 7 in a moment, but paragraph 8, we see what seems to be the judge's key point in the third sentence. I find it highly significant that the appellant contacted the Home Office and the administrator for ETS in order to request the voice recording of the test taker. I find that the appellant has acted in the way that would be expected of an innocent individual. I find the respondent, in failing to address or respond to the same, has failed to meet the burden reverting to him. Now, in my submission, that understanding of something like an evidential burden, or perhaps even a legal burden, is completely inconsistent with the guidance given in DK and RK number 2. It's completely unsustainable. It is also completely inconsistent, this suggestion that somehow the fact that the appellant obtained a recording that didn't have his voice on it, the suggestion that that somehow strongly supported the appellant's case, is just completely inconsistent with DK and RK number 2. And in particular, those passages from paragraph 104 and following that we looked at earlier, where and indeed other passages, where the upper tribunal is very clear that if an appellant obtains a voice recording that is linked to them by ETS and by the lookup tool, that is, on the face of it, reliable evidence that they've cheated if that voice recording does not contain their voice. So far from supporting the appellant's case, certainly far from being sort of dispositive in support of the appellant's case, which is how the judge seems to have treated it at paragraph 8 of his reasoning, this fact has strongly supported the Secretary of State's case. And yet the judge just doesn't recognise that. That's a very, very clear indication that the judge has gone seriously wrong and just doesn't understand DK and RK number 2, with great respect to him. And indeed, if we go back to DK and RK number 2 on this point, so that's tab 9. It's paragraph 130 and 131. Page 209. At paragraph 130, page 209, the upper tribunal emphasises how important it is that it is possible for an accused person to reach out to ETS and obtain a copy of the impugned recording. It said that that provides a further safeguard. But then the upper tribunal goes on to point out that in a situation where you get your record and you accept your voice is not in it, the issue then becomes, is there a sufficient evidence to show that there's a problem with chain of custody, as it's put at paragraph 131. And when you read those observations together with paragraph 104 and following of DK and RK number 2, it's clear that what the upper tribunal is saying is that if you get your voice recording and your voice is not on it, that constitutes strong evidence against you, especially in a fraud factory case. The judge's reasoning in this case at para 8 of the FTT's decision is just completely inconsistent with all of that. And just to be clear about the evidence that's relevant on this point, if we turn to the appellant's witness statement that was before the First Tier Tribunal, it's at page 37 of the appellant's supplementary bundle.
Yes.
Paragraph 14 on page 39. The provides the only evidence on this topic, but mercifully it's very clear. Recently, I obtained my voice record. I confirm that that is not my voice record. The voice has been mixed up with others. For some reason, the documentary material explaining the background to that was not included in the papers before the First Tier Tribunal, as far as I'm aware. You have that evidence. So the appellant clearly accepted that he had the voice recording, and he says there's a mix-up. That's it. There's also no indication as to when he requested his voice record, except, of course, that he uses the word recently at the beginning of paragraph 14. Now, this statement was dated, or is dated, March 2022, and the hearing before the First Tier Tribunal took place on the 20th of July 2022. But the appellant had been aware of the allegation of TOEIC cheating since January 2016, because it had been squarely put to him as the basis for refusing an application for leave to remain. You can see the 8th of January 2016 decision. It was in evidence before the First Tier Tribunal. It's at page 63 and following in the respondent supplementary bundle, and the relevant page where the allegation of TOEIC cheating is made is page 68.
Mr. Biggs, since you just paused, can I just check with you that you're on target to finish perhaps in the next 10 minutes?
I don't think so, I'm afraid, Lord.
Right. How long do you need?
I think I'm going to need at least another 20 minutes. I can try and finish in 15.
All right. Well, I think you should finish by 1 o'clock
Very well.
because this was a half day time
Yes,
estimate,
Appreciate that.
and obviously Mr. Malik needs a few minutes in reply.
Very well. I will speed up and do my best to finish by 1 o'clock,
All right.
if that's convenient. That's my second point. Third point, and I can make this point very quickly, the learned judge is clearly unaware of how the burden of proof operates and the fact that it doesn't shift.
Yeah.
You see that at paragraph 7, you see it at paragraph 8, and in the other passages where the judge relies on this point about the appellant having obtained his voice recording somehow going unanswered by the Secretary of State, and that's supporting the appellant's position. So that indicates the judge just wasn't aware of DK and RK number 2. Fourth point, English proficiency. Paragraphs 9 to 11 of the First Tier Tribunal's decision. I'll just give you references now, if I may, in the interest of time.
Yes.
Pages 44 to 45 of the core. As I pointed out, paragraph 108 of DK and RK number 2 makes it very clear that as far as the tribunal in that case was concerned, evidence of English proficiency is immaterial, essentially, to the assessment of the burden of proof. Now, even if that proposition goes too far, so that it's open to a judge of the First Tier Tribunal to treat it as a relevant factor, the fact that the appellant didn't need to cheat because they had adequate evidence. Nevertheless, as I pointed out already, a First Tier Tribunal judge would be expected to recognise the observations made at para 108 of DK and RK number 2 and to deal with them in turn. So the judge would need to explain why, in the light of those observations, he thought that this was a salient factor or indeed a weighty factor. The fact that in his assessment, the appellant didn't have a motive to cheat because of his English proficiency. But, interestingly, in this case, the evidence, in fact, does not support the judge's conclusion or the judge's reasoning in respect to that conclusion, that the appellant had passed academic courses with flying colours and had passed a number of English language tests. In fact, if we look at the evidence before the First Tier Tribunal, it's at pages 43 and I think 44 of the appellant supplementary bundle. The appellant had only one English language test other than the TOEIC, not the several tests that the judge seems to have thought he had. So this is page 43, an IELTS test. certificate dated the 4th of September 2010. So that's before, my lady, my lord, before the appellant came to the UK. So that's inconsistent with the judge's reasoning, because the judge says there were a number of tests. And the appellant only scored 4.5, which was B1 level. He needed B2 level in order to meet the requirements for a grant of entry clearance. And that's made clear from the document at page 3 of the respondent's supplementary bundle, which is a document contained within the appellant's bundle filed in the First Tier Tribunal, that helpfully sets out the different grading bands in respect of English proficiency. So this had to be grappled with, particularly bearing in mind the observations in DKNRK number 2 at 108, because this document did not indicate that the appellant was without motive to cheat. It didn't indicate he had the requisite level of English proficiency. And the same is true in respect to the document on page 44, which is the only other piece of English language proficiency evidence before the judge, apart from the appellant's witness statement. This is a certificate in respect of the appellant's Diploma in Business Administration, NQF Level 5, dated June 2013. Of the 4 units there, he passed and got the merit in 1. That does not constitute flying colours in my submission, contrary to the First Tier Tribunal's reasoning. And indeed, an NQF Level 4 course, and this is a matter I think the court can take judicial notice of, is not a course at the same level as a degree course, which is what the appellant was seeking to study at, and that's why he needed the B2 level TOEIC certificate. The judge just doesn't grapple with any of that. Fifth point, paragraph 14 of the First Tier Tribunal's decision about the APPG report. Well, I've already made it. That's just clearly unsustainable, and my learned friend is wrong to seek to minimise it. It was a factor the judge clearly thought was significant, otherwise he wouldn't have mentioned it.
Right.
Sixth point, there's no clear and adequately reasoned finding about credibility. On a close analysis of paragraph 12 of the FTT's decision, the judge is not saying, in my respectful submission, that the appellant was found to be a credible witness. What the judge is pointing out is that there are 2 factors that the judge found supported the appellant's case, and those tended to support the judge's conclusion at paragraph 8, or his more general conclusion, that the Secretary of State had failed to prove cheating. There is no careful and fully reasoned analysis of the appellant's credibility. And that indeed, in my submission, is inconsistent with DKNRK number 2. Seventh and penultimate point, if one carefully considers the appellant's witness statement, and in particular paragraphs 9 to 17, paragraphs 9 to 17 of the appellant's witness statement, his account really amounts to no more than a mere denial. And indeed, it is, in a number of respects, incoherent or flawed. So, given the time, I'm going to have to deal with this point very quickly. But if we turn briefly to the statement, and paragraphs 9 thereof, in particular, page 38 of the appellant's supplementary bundle, I've already taken you to paragraph 14. The key passage is probably paragraph 11, page 38. The respondent, without alternative opportunity, curtailed my student visa on wholesale basis. It's very unclear what he's talking about there. There is no curtailment, as I understand it. Please note that I have no recollection of the TOEIC exam or what happened on the day, contrary to what the judge says. This is due to the fact that it occurred approximately 8 years ago. It's quite difficult to recall, etc. However, and now this is the incoherence, however, I recall a few details from the test and the events of that day. For instance, I recall the TOEIC examination having 25 to 30 participants, etc. And he mentions taking a bus from Mile End. Well, the 25 to 30 participants is inconsistent with that global lookup tool we looked at, which indicated a larger number of people took the test. But in any event, this does not mesh well at all with the judge's analysis or statements in respect to the appellant's account. He doesn't provide any detail at all of the test, really. He says he can't remember it, but then he goes on to contradict himself. Finally, my lady, my lords, in respect to the flaws with the FTT's decision, well, this is a point I've already made, that the mere fact that the judge has referred to SM and Kadir at paragraph 8 doesn't help, and I've made that point. Can I just deal with a couple of further matters very, very briefly? So my learned friend relies on the fact that DK and RK was mentioned in the appellant's skeleton argument before the First Tier Tribunal. In my submission, that does not, on careful review of the skeleton argument before the FTT, support the appellant's case. If you look at the skeleton argument, it's at page 23 and following in the appellant's supplementary bundle. As far as I can tell, there's only 2 mentions of DK and RK number 2. The first mention is on, I think, page 25, paragraph 6, and it doesn't in any way go into the sorts of points that I've highlighted as being highly relevant in DK and RK number 2. The second mention is at paragraph 8 of that second annex that my learned friend drew attention to in terms of the legal principles, which is on page 34. There, my learned friend's predecessor submitted that DK and RK number 2 was wrongly decided. So the reality is that, for whatever reason, it doesn't look as though the learned judge below had much, if any, assistance on how important DK and RK number 2 was. But I can't help as to what, if anything, was said by counsel instructed by the Secretary of State before the First Tier Tribunal. I'm afraid the note doesn't assist on that. Penultimate point, UT's reasoning, Upper Tribunal's reasoning. We say that the Upper Tribunal's reasoning is adequate. I'm not going to be able to take you through it all in the limited time that I have available now. But in my submission, bearing in mind that the Upper Tribunal is an expert tribunal, and bearing in mind what the Upper Tribunal says when refusing permission to appeal, which in my submission can be taken into account when understanding what the Upper Tribunal had in mind, and just to refer you to the relevant references there, the refusal of permission to appeal by Judge Perkins is at pages 25 to 26 of the core. What the Upper Tribunal was saying is the grounds of appeal before me are well-founded. You've seen those grounds of appeal. I've given a number of points as to why those grounds of appeal were clearly well-founded and meant that the Upper Tribunal was fully justified in concluding that the First Tier Tribunal judge erred. Now, final point, if I need to, because the Upper Tribunal judge's reasoning is unsatisfactory in one way or another, if I need to, we rely on the respondent's notice. The respondent's notice essentially just puts squarely before this court the ground of appeal and relevant points in support of the ground of appeal that was before Judge Perkins. So if the court is concerned about the way Judge Perkins expressed himself, and I say that with great respect to Judge Perkins, then we invite the court to conclude that the judge got the right result by reference to the points made in the respondent's notice, even if his reasoning is less than ideal or is flawed in some way.
I may be wrong in this, which is why I need the assistance of both advocates. But given that the case has now reached the Court of Appeal, and given that the underlying issue is whether the FTT erred in law or not, and I stress erred in law.
Yes, I accept that it has to be.
Yeah.
We have to show.
Yeah, given that that's the central issue, Mr. Malik submits it did not. You submit that it did. I speaking for myself only, I'm wondering to what extent we're not marking Judge Perkins' homework, if I can put it that way, or is that the wrong way of looking at it?
No, my lord, it's absolutely not. Can I put it this way? The respondent's notice is belt and braces.
Yes, I understand.
That's the only reason we put it in.
Right.
It's deliberately seeking to cut short any focus on reasoning in the Upper Tribunal to get to the heart of the matter, which is whether the FTT erred for the reasons put before the Upper Tribunal in the grounds of appeal that my learned friend took you to in opening.
Right. Yeah, just check if there are any other questions. Thank you very much, Mr. Mr. Malik, you said that you would need 5 minutes.
Yes.
That's fine.
I'm grateful. Milady, my lords, I fear that I said a bit too much on cross-examination in my opening. I make it absolutely clear that I'm not making a new point. As said in my opening, I'm not asking the court to allow the appeal on the basis that there wasn't any cross-examination on this point. What I said on that was largely in answer to the questions that Milady and Lords were asking. If there is an error of law in the judge's reasoning, then the appeal fails. My learned friend says that the principles in ULA, the principles that I took you to, also apply on appeals from the upper tribunal to this court. Plainly, they do not. Those principles are about appeals from findings of fact made by the first tier tribunal to the upper tribunal. The upper tribunal is exercising a different function. The upper tribunal isn't making a finding of fact, but is deciding whether there is an error of law. So those principles as to the deference to the fact finder do not apply. My learned friend referred to the analogy with the country guidance cases, not a point that arises in this case, but perhaps can I just flag that so far as the country guidance case is concerned, there is a statutory basis for those cases. It's section 107(3) of the Nationality, Immigration and Asylum Act 2002. Section 107, subsection 3 of the Nationality, Immigration and Asylum Act 2002. You have that provision at page 219 of the authorities bundle. My learned friend then addressed you on DK and RK and said that 6 propositions arise from that decision. Well, the whole point of reporting a case with a judicial head note written by the judge is to summarize the legal propositions in that head note. 3 propositions from DK and RK of general significance arise, and those are the propositions that the judge, the tribunal in DK and RK summarized in the judicial head note. But I take no issue with the 6 points that I think my learned friend made. The burden of proof, he said, does not shift. The Secretary of State's evidence is reliable, no issue with that. APPG report, it's not that the report is irrelevant, but I accept that it does not substantially undermine the Secretary of State's evidence, so no issue with that. My learned friend made a point that proficiency in English language is not determinative, I think he said when he was addressing DK and RK, but then when he was addressing the decision made below, he said it's immaterial. I mean, surely it's not immaterial. I mean, surely it's not. The fact that a person is able to speak English is relevant. The weight to be given to it is a matter for the fact finder. In answer to a question by my Lord Justice Singh, my learned friend gave the example of convenience as why a person would cheat. Well, that may well be the reason, but let's compare, look at the facts of this case. So a person who took the trouble of passing other tests, who is going to the college for his studies, who took the trouble to actually go to the test center, his photograph was taken. Will he do that for convenience? Again, it's a matter for the fact finder. The Secretary of State's evidence is strong, I accept that. Can I then just very briefly deal with, my learned friend made 8 points as to the First Tier Tribunal's decision, and I'll deal with those 8 points very briefly, in a sort of summary format. So his first point was that the judge failed to consider whether the college in question was a fraud factory. That wasn't an issue before the judge. Fraud factory is a term of art. It relates to colleges where cheating was happening on a daily basis. Now, the Secretary of State would investigate those colleges and prepare what are known as project facade reports, directing to one particular college to say that, well, this is a fraud factory. If, my Lord, you wish to see the reference to that, it's paragraph 69 and 97 of Waki decision. There is no evidence that this Eden College is a fraud factory. There is no finding in Kadir, my learned friend took you to, which says that Eden College is a fraud factory. I ask you respectfully to look at the Secretary of State's decision in this case. This is page 44 of the core bundle. The Secretary of State is not saying in that decision that Eden College is fraud factory. The Excel sheet that my learned friend showed you are the results on one particular day. There's no suggestion, there's no evidence whatsoever that Eden College is a fraud factory.
Mr. Baddock, I'm getting a bit worried about time now,
Yeah.
because you've had your 5 minutes and you've only dealt with 1 of 8 points. It's better for you. Do you really need to go through each of the 8 points individually?
Okay. Can I just take take than 5 seconds just to deal with 5 seconds on each point. So I won't take more than 30 seconds. Lord,
Carry on.
so paragraph 8 of the First Tier Tribunal's decision, where the judge makes a finding about the voice recording, what the judge is really saying is that, well, what this appellant did is what an honest person would do. He asked ETS for his recording. What he was doing was indicative of an honest person. The burden of proof error is in the Secretary of State's favor. English proficiency, it's not immaterial. Weight to be given to it is a question for the fact finder. It was for the fact finder to evaluate the IELTS test and other educational courses. There is clear finding on credibility. The judge is not saying that the APPG report has undermined the Secretary of State's evidence, and this court, in my respectful submission, should not sit to evaluate the evidence for itself and decide whether the evidence in the witness statement was coherent or flawed. That was a matter for the fact finder, and the findings reached were open to the judge. I'm very grateful for the opportunity.
It's very helpful. May I check if there are any other questions? No, we're grateful to all concerned. We will reserve our judgments, and they will be sent to you in the usual way on a confidential basis. I must stress, as this court has frequently done in recent years, that it's very important that the embargo is respected at that point. A breach of the embargo is taken very seriously by this court. And we anticipate that it will not be necessary for there to be a further hearing for the hand down of the judgment. If there are any consequential matters, we expect that those could be dealt with in writing. Thank you all very much.
All rise at table.